Let me ask a couple of questions, and then I think we can conclude this hearing. There has been concerns raised about the recently adopted California Consumer Privacy Act. Those concerns, that act is expected to take effect in 2020. The concerns are that legislation will influence other states to enact their own versions of privacy regulations, each of which would potentially impose differing obligations on companies and different types of protections and remedies for consumers. As the federal agency that has primary expertise over unfair and deceptive practices affecting interstate commerce, what are your thoughts about this state-by-state approach to regulating privacy practices of U.S. companies, and whether that complicates the consumer's ability to enjoy the same privacy protections no matter where they live or use the internet? Do you believe that there is a potential for consumer confusion between federal standards and varying state-by-state approaches?
I'll take that. Sure, I think that is a possibility. If you've got a good federal statute, and you've got state statutes that are either inconsistent or varied, I think you can get confusion. And depending on the right, what the mix is and the details, federal preemption might be the way to go on that.
Mr. Phillips.
Thank you, Senator. One of the things that I've said publicly, including here today, about federal privacy legislation is that we should keep competition in mind. For large businesses, it's easy to deal with lots of different compliance costs. For smaller businesses, having one clear rule can help them compete.
Can I just add that of all the preemption that occurs, you should tread very, very carefully. We saw how preemption of state law in the mortgage market, and the same argument was used about making sure that there's enough entry, not confusion. That preemption of state laws there was catastrophic. And there are certain states that may want to have higher standards than the federal law. We can talk about material conflicts, but broad preemption, I think, would be a huge mistake. But I'm happy to keep talking about that with you and figure out how we can balance all the things you're concerned about.
I would say that I'm not concerned about states that want to have strong laws. I am concerned about the idea of inconsistent laws between states. So I think there could be a case for federal preemption as long as a federal law was really meaningful and really strong. I would be very concerned about a weak federal law that replaced strong state laws.
So I do respect federalism and states as laboratories for democracy. In the words of Justice Brandeis, the states provide an important opportunity to conduct novel social and economic experiments. And so I would be wary of advocating for preemption in very many circumstances. But I think in this kind of circumstance, it will be important to do that, I think, for the reasons that you described for consumer confusion, but also businesses need clarity and predictability so that we don't dampen innovation and chill competition. As Commissioner Phillips noted, if there are small companies trying to get into the marketplace and they're looking at a patchwork of laws, it raises the costs for them to enter. And so I think in this kind of circumstance, preemption would be useful for consumers and useful for competition itself.
I have great regard for everyone's commentary on this topic. It's a challenge. Ms. Slaughter, you did say something that catches my attention in that this may be the way to find the solution to this issue is by the strength of the federal law. In other words, there's a give and take that takes place here. Something that we can further explore as we try to figure out a solution to federal legislation. I support privacy rules that afford consumers the same protection no matter where they are in the internet ecosystem, slightly a different topic than the one that we just were talking about. Would you agree that regulating and enforcing privacy rules based on the sensitivity of the data collected, used, or transferred, or stored is a preferred approach and in the best interest of consumers in terms of certainty and transparency? In other words, the standard, the focus should be on the type of data that's involved. and its consequences of being impaired from privacy protection. Make sense? Senator, or I called you senator twice. I've disparaged your reputation on 2 occasions. I'm sorry. Commissioner Phillips.
In my heart, Senator, I'm still a staffer. What I would say is this. The system we have today in America, the system we've had for a long time, protects health information especially. It protects information about children. It protects financial information. And that reflects a collective judgment that there are certain kinds of data that the disclosure of which inappropriately may pose greater risks and may require greater care. Additionally, something we talk a lot about in the privacy world is that the idea of context, what consumer expectations are in a given circumstance, and that it may be reasonable for a consumer to expect more sensitive data to be treated with more care. So I definitely think there is a wisdom to how things have long been done. There's a collective wisdom reflected in our laws today. So I think that's definitely an important issue to keep in mind.
Thank you. Let me turn to a different topic. The FTC began holding open hearings in September to evaluating evolving technologies and business practices in an increasingly globalized economy, while also identifying possible changes to competition and consumer protection laws and enforcement priorities. Other topics, including data security and privacy, are scheduled to occur in the near future, as I understand, in early 2019. What would you describe as a high-level takeaway or priority action item that you've identified through this public process to date?
So
what have you learned so far, Mr. Chairman?
Yeah, so I think what we've learned so far is a lot of we've gotten views from both sides of the spectrum across a whole range, and so we're getting terrific input. We've had 200 people testify already from diverse backgrounds, and we've had a large number of written comments, some of them very detailed and very thoughtful. So we're getting a lot of input. I think at this point we still have more to go, and in particular we're going to get comments at the end of the process. So I think as of this point we are still absorbing the input and synthesizing it, and we don't really have any takeaways in terms of what a specific output of the hearings is going to be.
Senator, one initial takeaway I have is that data is a more and more valuable asset every day to firms that are in our economy. The traditional ways we have looked at how to enforce some of our laws, whether it be on the antitrust side or the consumer protection side, we are trying to develop further views on that because there's clearly a race to get all of our data and figure out how to monetize it in a big way. This raises some issues that we deal with. It raises national security issues, but we are in learning mode. But certainly, we have to accept that we are going to do our job in a very data-oriented economy where that is similar to gold.
Thank you for that comment. I'm going to just soon turn. I have one question, then I'm going to turn to Senator Cruz. This one for Commissioner Slaughter. As you are well aware, we were successful in enacting better online ticket sales, the BOTS Act, in 2016. We provided the FTC and state attorney general's authority to treat any, quote, circumvention of a security measure, access control system, or other technological measures, including online bots, to surpass ticket purchasing limits as an unfair or deceptive practice. I understand there's an upcoming workshop on this topic, and I was interested if you would explain this to me, but more broadly than that, how are we coming along on the enforcement of the BOTS Act?
Thank you for the question, Senator. This is one of those issues like robocalls that people really care about. Consumers really, really care about it, and it really makes them nuts when they cannot get tickets to their favorite show or a play. And that's an important thing for us to take seriously. So it was my pleasure and privilege and honor as a Senate staffer to work with your office on the legislation, and now it is my pleasure and privilege and honor to be in the position of considering the enforcement of it. So I would say two things to you. First, in terms of enforcement, we're actively monitoring for enforcement opportunities. It's an important tool that we've been given, and we need to use it, and we would like to use it. And then in terms of the workshop, our goal, I think, is to gather stakeholders, get input to make sure we're staying abreast of the technological developments in the ticket industry. It is a very fast-moving target, and so we want to make sure we know what's going on, we're targeting our investigations and enforcement efforts appropriately, and that we're appropriately communicating with you to make sure that we continue to have the tools we need to try to tackle this important problem.
Do you have any colleagues as commissioners who don't share your enthusiasm for the Bots Act that I need to question?
I cannot imagine that any of my colleagues don't share my enthusiasm.
Maybe I should
here.
ask them. Are there any commissioners who do not share the enthusiasm for the Bots Act? I see.
That was a double negative, but we share her enthusiasm.
Thank you. Senator Cruz.